Good afternoon, everybody. This is Jim Gleason, and I'm here today with Josh Brown of Indiana Franchise Law. Good afternoon, Josh.
Good afternoon, Jim. How you doing?
Good. How are you?
Doing great.
I'm going to give a brief introduction, Josh, here, and we're going to cover the legal aspects of franchise law today. And franchising is a great way to get into business, and obviously, there are a lot of laws that go with it. Franchise industry is regulated by the Federal Trade Commission, and there are certain states that are called registration states that, in addition to the Federal Trade Commission, they have their own regulations. And so it's important to have an attorney that understands franchise law when you're looking at getting into the franchise world. Josh has been involved in this for several years. He and I have been having conversations for probably 8 or 10 years now about different aspects of franchising. He works with franchises setups. He helps to set up franchises, new franchises, helps folks that are looking to get into the franchise world by doing franchise disclosure document reviews. He helps folks also through licensing structure and all the aspects of getting a small business set up, trademarking, licensing, etc. And Josh has also been very successful with a blog where he has a lot of different content specialists come in and provide additional information about franchising and just business in general. And so with that, Josh, I'll let you take it away, and we'll just cover the information today that you have ready.
Thanks, Jim. Really appreciate the Indiana Business Advisors and you putting this webinar on. Obviously, it's something that's near and dear to me, helping people who are looking to buy a franchise and do it the right way, because unfortunately, so often it's done the wrong way. And one of the things I've enjoyed so much is just working with people across the country in helping them do this. Now, one of the things I'll say at the outset is certainly as part of a webinar today, want to make this more of a discussion. I mean, I'll take some time at the beginning here to go over some things, but would love to have a discussion and be able to take some time to answer questions for everyone during this time, because I usually find that's the most valuable part of the webinar. And of course, in 1 hour, it's a little bit challenging to go over every legal aspect, because anybody who's looked into a franchise system and has gone as far as getting their FDD, or what's the franchise disclosure documents, understands that it's a big amount of paper, 300 pages plus, that break down the franchise system. So what I've created over the years, and that I update every year, and what you're seeing on your screen, is what I call a lawyer's guide to buying a great franchise. At the top it says Franchise Euphoria, because that's the name of my podcast that I've had for 6+ years running, where I interview and speak with people in and around the franchise world. So if you listen to podcasts, I'd highly encourage you to check that out if you're interested in obviously franchising and various aspects of franchising. But one of the things I've done through this guide is I have taken the 23 mandated items that are part of every franchise disclosure document. So anybody who turns their business into a franchise has to create what's called a franchise disclosure document. And the first part of that document is going to include 23 mandated items 1 through 23. And essentially what that does is it tells the prospective franchisees all about the franchise system that they're reviewing. And it's a extremely important aspect of the franchise review process, because it's really your window into the franchise system, where you learn all sorts of aspects about the franchisor. But at the same time, you have to know how to read the FDD, because of course it's the franchisors who are putting it together. So they're the ones who are deciding through their counsel what to include, what not to include. So I've been doing this enough that I think I can provide some good insight into pointers that you can take as you're reviewing the FDD, so you can glean more information and sort of look beyond what's just on the page and help you identify whether it's a good franchise for you. We won't have time today to go over all 23 items, but I figured I could give just a brief account of those items, and then I'm going to focus on some of the ones that I consider to be, more important, more relevant from the legal side of things. So, with regard to the items, item one, as you can see here from my introduction, is all about, I'm sorry, from the table of contents, is all about the franchisor and any parents, predecessors, and affiliates. So basically gives you a background on the franchise system. Item two talks about the business experience of the folks who are running the franchise. And this is an important one to pay attention to because, oftentimes, and I'm amazed at this myself when I review these documents and I look into, okay, so what is the background of the people who put this franchise together? So often it's people who don't have that much more experience than the people who are actually buying into the franchise. And to me, that's a very important aspect to look into because you certainly, you're buying into a system that ideally is a proven system so that you don't have to go out and create it yourself. And if you've got people who have put the system together and you realize that they don't have a lot of experience in that industry or they don't have a lot more experience than you do, then that's certainly something to factor in before you make a decision on buying the franchise. Item three, litigation, of course, is an important, very important legal component to the FDD. And one of the things that is is often overlooked is that when people are reviewing the FDD, they usually skip over the litigation component of it. And the reason they do is because nobody wants to deal with litigation. But the reality is that if you are buying into a franchise system, and I'll just scroll down here to go to the litigation piece, but if you are buying into a franchise system, of course you need to know what kind of litigation past the franchise has, what current lawsuits are pending, and they're required to list that in their FDD, which needs to be updated and by law has to be renewed every single year. So not only can you gain some insight into why are they in litigation if they are, you can gain insight into who sued them. You can see if it's current franchisees who are in suit with them. And I always want to pay attention, and I always tell my clients to pay attention with litigation to look at what the claims are that franchisees are alleging. Because if you start seeing claims in the FDD that are fraud, material misrepresentation, and any of those sorts of intentional torts that lend themselves to fraud or really bad activities, you really got to pay attention to that. Obviously, that's something that you want to know of, and it's something that franchisors, frankly, don't want to have to include in their FDD, but they're required to. So it can serve as well as a deterrent for franchisors to get into litigation because they know that if they do, they're going to have to report it in their FDD.
Hey, Josh, this is
Yeah.
Jim. Yeah, when you see that, have you seen cases where perhaps you've got an upset franchisee that's not performing the way they should, and they're coming after the franchisor when in fact it has more to do with their non-performance, and they come through and then end up being in some kind of legal situation and ends up in the FDD? And how do you distinguish who's quote unquote at fault in this to determine if it's a franchisee or franchisor issue?
Well, yeah, you see that all the time. And so what we always do is even in the FDD, if it says no litigation, we search through, there's various court websites that we have access to that we can actually do a name search and find out if there's any litigation that they haven't listed. But we always do that when they list the litigation, and then I look into it for the clients because I want to see. I mean, you're exactly right. I mean, anybody can file a lawsuit and allege fraud and you materially misrepresented this, but they're going to have a complaint that they filed that's public knowledge, public record, if it's through the court system, that we take a look at the facts section and we say, okay, let's see what happened. I mean, you can have something where you read it and you go, yeah, this doesn't really pass a smell test. I don't think this is,
Yeah.
I don't think this is legitimate. Of course, you never know until if they're in the middle of a case, but it's certainly something that, I always encourage people to ask the franchisor. If you haven't gone to a discovery day, which, for anybody who doesn't know, as part of buying a franchise, you're going to have to go through a discovery day where you go and, you meet the franchisor, you meet the team, and you have an opportunity there to ask a lot of questions and really dive in. And I always encourage people to ask about the litigation, and let's hear what the franchisor has to say. But certainly, you don't want to judge a book by its cover and just assume because there's litigation that all of a sudden you run from the system. Because here's the reality, and you know this, Jim. I mean, anytime a system gets big enough, there's going to be litigation.
Yep.
I mean, you just can't avoid it because you can't stop somebody from suing you. All you can do is put yourself in a position to defend it and
Hmm.
to have proper, disclosures and good documentation so that the suit doesn't go anywhere. So
And that's what I think is important is that as a non-attorney, when I see litigation, oh my gosh, somebody's done something terrible, and no, I think the automatic assumption it's probably going to be the franchisor. But I was recently visiting a franchise, and there was some litigation actually about money laundering, and it came out that it did not happen, and there was all kinds of misrepresentations as to what the litigants were alleging about this guy, and they weren't true.
that happens a lot where, if you just ask, sometimes prospective franchisees are afraid to ask the franchisor about the litigation, but I say, well, ask them. And
Yep.
if they give you an explanation, and you feel like it's a good explanation and not, them sort of trying to come up with a good explanation, I think people can tell a difference a lot of
Hmm.
times. And certainly there's always two sides to a story. But I also encourage that, if there is a lot of franchisee litigation, one of the things that
Hmm.
anybody who looks into a franchise should be doing is reaching out to franchisees within the system and speaking to them,
Yeah,
asking them questions. Yeah.
that we talked about that last time. That's in our world. That's called validation. And just to emphasize what Josh was talking about, do not be hesitant to ask any question, because if they're reluctant to answer a question, that's an important question that you need answered.
That's exactly right. Well, and then the next item as we kind of scroll along here, is item 4, which is bankruptcy, which, this is interesting. I got a good story to tell about this. In most instances, when you're dealing with a franchise system, oftentimes you're not going to see a bankruptcy because they haven't gone through a bankruptcy. But there is a fair amount of times where they've gone through a restructuring or there has been a bankruptcy, and so they will have listed that, or their directors or owners or officers have gone through a bankruptcy, and they need to list that as well if it's within a certain time frame. I had a case not that long ago where the in this particular case, it was the franchisor had listed that there was no bankruptcy, and we came to find out that there was within the last couple of years, and that ended up becoming a very significant and important piece to getting the entire case resolved. Because if you, as a franchisor, don't disclose a bankruptcy, I mean, just think about it from the perspective of, the purpose of these disclosures is to give the consuming public information. Don't I would think it'd be pretty important for you to know whether or not the business you're about to invest in has gone through a bankruptcy, or if any officer who runs the business has gone through a bankruptcy, him or herself. So this is one of those things where we dive into this as well, and it's a really important aspect to look into. And usually you find out pretty quickly, either there was a bankruptcy, and if it's listed, or there wasn't, and you just move on. But certainly one of those things you just don't want to skim over.
Hmm. Very good.
All right. I'm going to kind of scroll through these a little quicker. And by the way, at the end of this, for anybody who's in attendance, if you just email me or Jim, but I'll give you my email, Josh at indiefranchiselaw.com. I'm happy to send you this entire document. It's about a 50-page, very thorough document covering all these various aspects of what you need to know when you're trying to look at a franchise. So don't feel like you have to, take copious notes on all this here, because I'm going to be skipping over some of these. That doesn't mean they're not important, but we just don't have enough time today to cover all of them. And you'll kind of see as I'm scrolling through where, like right here, red flags and remaining questions. What I've done in this document is for each item, I've categorized it as what it is, why it matters, what to look for, and then I've put in red flags and remaining questions. And I've done this because one of the most valuable things you can have as a franchisee or prospective franchisee is questions to take to your franchisor as you're going through your due diligence process. So I felt like that was a valuable piece to add in there. So with item 8, I'm scrolling here to item 8, restrictions on sources of products and services. This is an important legal component of the FDD because in most franchise systems, you'll see if they're selling products or services, the franchisor is going to want to restrict what products and services you're providing and have total control over that. And that's fine. And I understand that from a system wide protection and make sure there's consistency and so forth. But one thing to know about in Indiana and in certain other states that have their own franchise laws is that if you as a franchisee can find a product or service that's of similar quality and standards of the products or services that your franchisor is offering, and you can find it at a lower cost, they can't refuse your ability to not buy those products or services at that lower cost. Now you have to provide them with the opportunity to research it, make sure that it qualifies, make sure that it meets those standards, but they cannot unreasonably withhold their approval of that. This becomes really important, and I see it over and over again in restaurant concepts, because what happens is you get tied in. I'm sure you've seen this, Jim, where you get tied into a national distribution structure, whether it's with a Cisco or whatever company that it is, which they do great work. But sometimes, if you're running a sandwich shop and you run out of lettuce, you have a couple options, like, well, we won't serve lettuce for the rest of the day because I can't get a shipment from Cisco, or maybe I need to go across the street to Kroger and go get some lettuce.
Yeah.
So you have to think about these things. But I've literally worked with clients where the franchisors have sent them default notices because they're going and buying lettuce from Kroger's across the street as opposed to getting it from the national distributor, or they're going and buying, the same kind of, cheddar cheese, but it's just not coming from the same source. And so they'll couch that as, protecting the quality, of the food and the brand. But there's a practical component to it of you got to run a business, and you certainly don't want to be telling your customers, hey, we're out of cheese, so we can't provide that for the rest of the day. But believe it or not, this is something that comes up all the time, especially in restaurant concepts. So I wanted to highlight that.
Mm-hmm.
You have any experience with that, Jim?
I just visited one last week. It was a food concept, and that was a big part of the discussion is where do they get the product? And there was a lot of discussion that the franchisor had to approve the different sources of the food because of that's their product, and they want to control that brand. And to do it at a reasonable cost as well. So yeah, I've seen that, and I've talked to franchisees that they go to Sam's or whatever, or to Kroger's to get something just to fill in when they can't get their regular supplier. But you like you say, you're a small business person. You got to keep running the business. You got to keep the doors open. So you do what you need to do in maintaining the integrity of the product as much as you can.
Yeah, and you want to make sure that when you're negotiating the franchise agreement, that you or your counsel puts in a clause in there that if that scenario arises, you have the opportunity to go to another location if it's some sort of an emergency situation or you run out in a particular day. I mean, it's really important to include those in the agreement.
Yeah. Just kind of a side comment as you're all, and again, we encourage you to type in any questions. But as we're going through this, you can see that this is a very involved document. And I'm just wondering, Josh, that when you get into reviewing one of these things and you're having to do all this research, what's it take you about 6 months to review one of these for a client?
No, I've done, I mean, hundreds. I don't even know the number. So we have a process that we go through, and so I've got a team of people that work with me, and essentially it's a 2 week turnaround time for when we review this. So we get the FDD, we do a full customized review of the franchise agreement and go through the other important aspects, and then make a red line and then create an addendum to the agreement. And that whole process is about a 2 week turnaround time. But you're right. I mean, it's only because, I've been doing this long enough and for so many years that it doesn't take 6 months to do it. So,
Well, and that's why I wanted to point this out because I'm sitting here and and I've read FDDs and I'm pretty familiar with this stuff. But as you talk about, well, I've got to research this if there's this litigation or that litigation, if I'm not familiar with how you work, I'm thinking, but my goodness, just this process, this part of it's going to take months before I'm able to even get into the business because I have to have this reviewed thoroughly. And I wanted to have you point that out.
no, no, I appreciate that. And it's also a relatively small investment cost to have this reviewed as compared to, the amount of money that you're going to shell out for the franchise
Oh,
system.
that's
Um,
absolutely true. Yeah.
Yeah, and I can't tell you the number of people who call who don't get an attorney, and then they call afterwards and say, "Yeah, I don't like this system. I just want to get out of it." And it's like, well, you, they're kind of tough to get out of once you sign the dotted line, but I'll
What's
see what we can do,
what's the old saying? Pay me now or pay me later.
That's exactly right. Yeah, I mean, people who try to save a little bit on the front end and not get good counsel always
Yep.
sometimes they pay triple, down the road to try to work out of it if they even can.
Sure.
So item 12 talks about territory, and there's a whole bunch of good information in here about that. And this is such an important component. And I'd love to get Jim's comment on this as well. In when in a lot of franchise systems, most franchise systems, you actually have a set territory. Here's your boundaries. Here's where your franchise business is going to be located, but it's not required. And you have to have in Indiana a reasonably protected area, but it doesn't have to be a defined territory. So sometimes people get confused on that. They think they have a protected territory because of the way that the franchisor is discussing it, but in reality, when you read the documents, they don't really have a protected territory. They sort of just have a general geographic area. The other thing that is so important when you're talking about a territory is within the franchise documents, oftentimes franchisors will carve out or try to carve out exceptions to the territory. As an example, they'll say, yeah, you've got a protected territory here of this, 5 mile radius, but we have the ability as a franchisor to come into your territory with non-traditional locations.
Mm,
That's sort of key language that a lot of them like to use. You go, what the hell is a non-traditional location? Well, oftentimes a non-traditional location is, opening up a satellite one of the franchise on a college campus, or opening it up in a dorm room, or something that's not really a full scale operation, but they categorize as a non-traditional location. And when they do that, you have to be really concerned about that, because there's a legal term of art called encroachment, where basically you start putting too many franchisees too close together and they end up killing each other. And
mhm.
as a franchisee, you have to be cognizant of the fact that, if you're paying for a full brand operation, and they're going to have the opportunity to come in and put it in a dorm room, or in a union, or oftentimes at an airport is an example, right? Hey, you've got protections, but if we open up one in the airport, you got to ask yourself, a, is that going to help you because it's going to further, the how well the brand's known, or is it going to hurt you because depending on where that location is or where that could be, people are going to go there or order from there instead of ordering from you. The other big aspect with regard to a territory is that obviously with everything being online, the internet, the digital age that we're in, oftentimes franchisors will sell products online through their website or through other third-party websites. And they'll do that within your territory. So one of the things that I often try to do is when I'm working with somebody is try to carve out that if they go and they're selling something online and somebody orders it from a zip code that falls within your territory, you as the franchisee should get a percentage of that because that's just like operating within your territory. And I've successfully gotten that into tons of franchise agreements. Now, I've also had instances where they say no, but that's just something to think about when you're contemplating and looking at what the actual territory is that you're getting. And of course, territory from a business perspective is one of the most important things. It's location, location, location. So you obviously have to think about it from the business side as well.
Yeah, the demographics are I make the statement franchises live and breathe by demographics or live and die by demographics, and they need to know what their demographics are, and they need to know the demographics of the area that you're looking at to see if it fulfills what their requirements are in order for you to be successful as a franchisee. What Josh just mentioned about the online stuff, I've seen franchises that a big part of their working with the franchisees to help them be successful is that they do when they do the online part of it, they do very much look to see what territory it's going in and give credit to that franchisee, because good franchises make their money from their franchisees on the royalties, and so they want you as a franchisee to be successful. They have a financial investment in you being successful so they can be successful. So it becomes a very much a strong partnership and not a competitive nature.
Yeah, and so then we go to item 13, so the trademarks. And this is where you get into the intellectual property of a brand, which, is a huge, huge component of franchising. I mean, obviously, when you're buying into a franchise, sometimes they're new, and sometimes you go in understanding that this is a newer franchise that's hoping to grow. But oftentimes, you want to buy into a franchise that already has a name established with it, because if you open it up in your territory, you're going to have credibility from the get-go, and it's not just going to be, you know, a local operation that nobody's heard of. It's going to have some cachet to it. One of the things in a franchise in the FDD, in the franchise agreements and the FDD is, believe it or not, they don't actually have to have a federally registered trademark. And that would be registered through the United States Patent and Trademark Office, the USPTO. Obviously, when I'm reviewing these, I'm always looking to make sure that they do have a federally protected name. I have seen many situations, represented many people who spend hundreds of thousands of dollars and buy into a franchise that's a certain name, just to come and find out that 6 months in, they have to change the name because the franchisor did not adequately protect its name or
Hmm.
register its name. It didn't have the rights to it. So somebody else had superseding rights to the name. And now everybody within the franchise system has to change the entire brand. And here's the biggest catch. In the franchise agreement, it's going to say that you as the franchisee have to pay for that. So it's no fault of your own, but you have to go and pay for that. I always try to work in and negotiate that if that is the case, then one of two things can happen. Number one, franchisee is not going to pay for it or is only going to pay for a part of it. Number two, the franchisee at his or her option, if that happens, can sell at that time at either a predetermined price or a predetermined structure to figure out the market value at that time and get out. There are just horror stories where, people are going along doing well, and then all of a sudden they have to change their name. And the cost associated with that, to change your name, change your branding, change everything that you have. If you've got wrapped vehicles, I mean, you name it. If you got signage, you've got all that, you got to change all that, can be astronomical and can literally just take you from a profitable enterprise to nothing, to bankrupt. So trademarks, the names, the intellectual property, it's very important to look at item 13. And we always check with the USPTO and see how they're registered, what they're protected in, because when you register a trademark, you have to register within certain classes. And I've had scenarios where they're registered, but they're registered in the wrong class. So in the class that they're supposed to be protected in, they're not. So somebody else comes along with a similar or same name in the right class, and they send a cease and desist letter, and you're in the wrong class, then your rights are subversive to theirs. So you got to be really, really paying attention to that, and have your legal counsel definitely look into that. All right, we'll kind of scroll down since we are at 12:30 here. Let's go to item 17, which is renewal, termination, transfer, and dispute resolution. This is a very important item as well, because of course, when you're buying into a franchise system, oftentimes the average franchise is 10 years. I've worked with ones that are 5, I've worked with ones that are 20, but the average is about 10 years. Certainly you want to know when you're buying in, what are your rights to renewal, assuming that it goes well. How many successive 10-year periods are you being allotted? You additionally want to know how you can terminate or how they can terminate the agreement, and what the parameters are for that. And then of course you want to know about transferring your business. Sometimes people have a lot of different reasons for getting into franchise businesses, and I encourage you all, before you sign and get into one, that you are very, very clear on what your reason is. But if your reason is to build it up and then sell it, then you obviously want to pay very close attention to the transfer provisions within the franchise agreement that are going to tell you what you need to make sure that you have done in order to appropriately transfer the business or sell the business to somebody else. Oftentimes, go ahead.
One of the things that you need to be looking at is, as Josh said, what are the transfer provisions, but also you need to be planning that as part of when you get into the business. That's one of the things you should start planning from the beginning, is what am I going to do when I'm ready to move on? And there's some provisions that you need to be looking at as the franchisee, because I've done some resales that, tell you what, they were became very difficult because of some of the provisions that the franchisor had that nobody was aware of until we got to that point. So it got rather sticky toward the end there. We almost didn't get them done, but we did. So
yeah,
it's part of the planning process. Yeah,
you got to start with the end in mind. I mean, you really got to think about what your possible succession plan is.
Yep.
Sometimes people get in because they want to have a business for their kids, and just pass it on. A lot of times, though, people get in because they've been in corporate America for a good period of time, saved up a nest egg, and want to have a go at it and be their own boss, and they just want to run it and either sell it at the end or pass it on to family members. I mean, there's lots of reasons that you want to do it. One thing to know, though, is usually, almost always, there's a fee associated with the transfer, and that can be negotiated to be either paid by the buyer or the seller, or as they would call it, the transfer or the transferee. But sometimes in these agreements, it'll say specifically, one party has to pay for it. I always like to have it set up to where, if the fee should be, it should be a reasonable fee. Oftentimes it's $5,000, $10,000. I've also seen it as a percentage of the upfront franchise fee. But you want to make sure that that's a reasonable fee that they're charging. And because when you're factoring in down the road selling your business, you have to understand that when a buyer is going to come in, they're not going to be thinking about a transfer fee. So whatever that fee is, that's going to either come out of their pocket or it's going to come out of your pocket. And so it's going to impact the nature of the sale. So you got to be thinking about that. The last part of item 17 talks about dispute resolution, which is obviously another, a more articulate way to say when the franchisees and franchisors are fighting, or if it goes to litigation. And in most franchise, we talked a little bit about this earlier, but in most franchise agreements, they're going to have mediation requirements and arbitration requirements. So a mediation requirement is when before you can sue, or they can sue, you have to go through what's called a mediation, where you get an independent third party to come in and help try to resolve the dispute. I always recommend mediation because it gives the parties a way to have an objective third person come in and kind of give their thoughts on what it is, on what they think is going on, how they think it it can be resolved. There's nothing mandatory about you having to resolve it with a mediator, so it's just a very good process to go through. One thing to pay attention to in these agreements is where a mediation would have to occur. And oftentimes they want to put it as close to the franchisor's principal office location, and of course if you're across the country, that's not exactly convenient. um, but in addition to that, they will often have arbitration provisions within franchise agreements. And arbitration provisions is where you have to go through, it's an alternative to going through court. And courts will uphold arbitration provisions so long as they're, well drafted and clearly drafted. And one of the big keys and a reason why franchisors love to have arbitration provisions is because if you go to arbitration, that's a private process, and the franchisors don't necessarily have to disclose those details in within the franchise agreement within item 3, but they do when it is obviously in a public court setting. So that's oftentimes why there's arbitration provisions within. One thing to pay attention to. There's a whole lot of things to pay attention to in item 17 and certainly with dispute resolution, but one thing to pay attention to with regard to arbitration is pay attention to how they're limiting your rights. Oftentimes they'll say, well, you got to go to arbitration and you only get, one deposition, and you get, you get this many documents. And so they're really trying to limit your ability to litigate, which in Indiana and in other states is does not comport with the Indiana franchise statutes. But it's one of those items where obviously you need to make sure that your legal counsel and your legal counsel should know already to pay attention and to look at that extensively. Let me move on to item 20, which I'll do item 19 and 20. Item 19 is often the most important, or certainly up there within the FDD. And that is, it's a financial performance representation that the franchisor is making. And there's all sorts of caveats and rules that have been construed by the FTC on what they can say, what they can't say, how they can say it. You as a franchisor don't have to have a financial performance representation. So if you're looking at a franchise agreement or you're looking at your franchise and they don't have one, then there's just no financial representations that they're going to be able to make. When I'm working with the franchisor and I'm creating these documents, I encourage them to do a financial performance representation, because I think as somebody who's investing in a franchise, you would want to know a little bit about their historical performance, and we will work with them to figure out the best way to make that representation. But this is item 19 is one of the most highly litigated aspects of an FDD, because oftentimes franchisors can mislead with the information that they're putting in there. And so you and your counsel really need to make sure that you're paying attention to item 19.
Yeah, and that's an important one that I deal with clients on all the time, because obviously as a potential franchisee, you would like to know what you can reasonably expect to make in this business, and that's where this is disclosed in item 19. And I tell my clients that just because a franchisor does not make an item 19 disclosure, and I started out before in the days before there were many franchises did not make that disclosure because of the concern of how it had to be worded. It does not mean that franchisor is trying to hide anything. It's just that the fact that it's something that and this is my assumption, is that their attorneys are a little bit concerned about how to do that, and so they choose not to. When you, as a potential franchisee, start doing validation, you can talk to franchisees, people that are doing today what you would do tomorrow should you get into business, and ask them questions about break evens and can I make X number of dollars per year, and how soon can I make that? Because they can then disclose their own experience.
Yeah, exactly. And I encourage you to do that, definitely. And I encourage you to do it in person if you can. Obviously, if you got to hop on a plane, that may not be practical. But if you can drive to some other franchisees, you got to sit down with people, because it's a lot harder for them to BS you if they're sitting down with you than it is when they're trying to get you off the phone, because they've got 17 other things they're trying to get done with, right? Just like everybody else. Um, Let me real quick, because I know we got 20 minutes left here, go to item 20 and 21, and those are the last two I'm going to cover, and then we'll open it up for questions and further discussion. Item 20 is such an interesting aspect of the FDD. It gives you all these charts and information on the outlets and other franchisee information. So in line with what we're talking about here about calling franchisees and talking to them, I study item 20 in the FDD heavily because these tables that they provide can tell you so much information about the franchise beyond the numbers that are listed. Um, the tables themselves, as you can see on here, provide system-wide summary of outlets and the net changes in the number of outlets over the last 3 years. So you can start looking at that and figure out what's the trend of this franchise, right? If all of a sudden there were 40 locations and now there's 27, obviously you're going in the wrong direction potentially, but maybe not necessarily, because it all depends on why. Maybe they extended themselves too fast. Now they're restricting, and it's going to give them the impetus to move forward. Table 2, providing the number of transfers from franchise owners to new owners. That's a real important one. You want to know, okay, does it look to be a trend here? Why are more and more people who are getting into this trying to get out of it and sell it? Was that their plan going in, or was it something where they got in and they just wanted to get the heck out of it afterwards? Table 3, where you're talking about the change in status of franchised outlets, and table 4, change in status of company-owned outlets. This is a great way to get an idea of how many franchise locations are there versus how many company-owned locations. Sometimes the company will start buying back the franchise locations, and sometimes it's not for a bad reason, but you definitely want to know why. You definitely want to understand, like, why over the last couple of years are you now buying back all these franchise systems? What's the purpose of that? You can really study these outlets if you know what you're looking for and find some great trend lines that are really, really important to help you as the franchisee identify where this franchisor is going, because it's really difficult when they're presenting themselves at the outset with this sort of perfect picture to kind of see through it and figure out what's really going on. And of course, table 5 is going to show the projected new outlets in each state, both franchised and company owned. And so you kind of get an idea of what their growth trajectory is, or what they hope their growth trajectory will be. So I actually love this. One of my favorite aspects of the FDD is studying item 20, because I always feel like I can find out so much great information and then really help my clients start asking questions of the franchisor, like, hey, why are you doing this and why are you doing that? And you can really start getting down to the nitty gritty of what's going on with the franchise system. And then lastly, financial statements. Of course, item 21, it's a requirement that franchisors provide audited financial statements for the last 3 fiscal years. Now, there is an exception in various states, like in Indiana. If you're a brand new franchise, your first year of being a franchise, you don't actually have to have audited statements. You have to have a balance sheet and you have to have a letter from a CPA. But after you've been in operation for a few years, you then have to have audited financial statements every year. It goes without saying that you and your CPA should be sitting down and going over these financial statements and asking any questions that you have to get a better understanding of the financials of the franchisor company. And again, for whatever reason, this is often one of those things that franchisees overlook, and I've never quite figured out why, other than they just don't want to dive into the numbers because it's not sexy, it's kind of boring. But at the end of the day, the best piece of advice I can give it to anybody is, don't ever buy a franchise because you think, oh, I just never see them shutting down. You have to understand the business model of what makes them tick, because, you might have a false sense of how profitable they actually are. I mean, I've worked with tons of people who own multiple locations, and a location that may be losing money is only staying in existence because there's 5 other locations that are keeping it afloat.
Mm-hmm.
And so you really have to dive in and understand, the numbers and everything else that's associated with the franchise system. So I know I went through that kind of quickly, but again, you can see there's so much information here. Like I said, all you have to do is email me, josh@indiefranchiselaw.com, and I will just send you this entire, PDF. Like I said, 43 50 pages. I think you'll find a lot of great information in it. So with that, I guess Jim will turn it over to questions or further thoughts.
Yeah. Well, just a comment about item 20, where you're looking at the franchisees that are existence. I've mentioned a couple times about validating, in other words, calling franchisees that are in existence. And this is one of the places where you can get that information. The franchisor will should be providing that to you too. They'll provide you usually with 4, 5, or 6, or 7 that they would like you to contact. But all the franchisees that are in existence at the time of the publication of the FDD are listed here with their contact information, and you have complete access to the full number of the franchise units out there that you can contact. So that's an important aspect as well.
Yeah, that's a great point I did not mention. Thanks for mentioning that. Yeah, it does list their address, their phone numbers, their email, and so you definitely want to be reaching out. But you want to do it in a thoughtful way. So
Yeah.
definitely, I would have questions written out that you want to ask, and then follow up from them. It's like it's a really important part of the investigation that you're doing into the system.
Yeah, and we provide those type of things if when people get to that point, even if they're not working with me as a consultant, I'd be glad to provide those. So yeah, there's a couple questions that I've run into over the years, Josh. Just kind of interested to hear your comment. I'll have a candidate looking at a franchise and they're getting pretty far down. They've gone to Discovery Day and they're going, well, I'm pretty sure that I'm going to do this. And I'll ask them if they've had an attorney review the disclosure document in the agreement, and I'll get comments, and it just kind of sets me back a little bit that, well, this franchise has been around for a long time. They're not going to negotiate anything. They've got 100, 200 franchisees that have already reviewed all this stuff. If I can't negotiate, why would I even have an attorney review it? Because there's no point in it, because there's nothing that can be changed. My comment is, an attorney wrote that document. I would suggest having an attorney review it. And more importantly, you want to know what you're signing, because you're going to be in relationship with this franchise for 5, 10, 15 years or more. So you better make sure you understand what's in there. And if I'm not an attorney trying to read that, there might be some language I don't understand. What are your thoughts, Josh?
Yeah, I couldn't agree more. There's two ways to look at a review of an FDD, and one is from an education perspective, and two is for making changes. And when I say from an education perspective, I mean, you as somebody who has not written the agreement, isn't used to reviewing these agreements, you can read it and you can gain a lot of information.
Mm-hmm.
But what a good franchise lawyer will do will be able to break all that down and explain to you, hey, here's what this means and here's what you're really getting into. Are you okay with that? The second component is making the changes. I find more often than not, I mean, I think it's a myth. I find more often than not, franchisors are willing to make changes. Now, it varies to what degree they're going to make changes, but franchisors will make changes. I've had experiences where, every single change I've recommended, they just incorporate and move forward. I've also have experiences where they will be difficult and they'll say, we're not going to make any changes. Well, then you kind of go back and forth a little bit and you kind of narrow it down. And usually when push comes to shove, they will make some changes. I mean, the reality is this, and this is what you as a franchisee have to understand. This is a negotiation. Oftentimes they want you more than than you need them, right? I mean, they're looking to expand, and oftentimes they're going to be applying a lot of pressure on you to get the deal done fast, 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 because they're going to say, well, we've got other people looking at the territory, or and I always tell my clients that taking an extra couple weeks to review these things and do that is, I've never seen a deal killed over that. And at the same time, when you are working with your franchisor, they're giving you their best look at that time. And you're not going to get a better look or a better feel from them after you sign the agreement. So if they're being extremely difficult and won't make any changes, even the most reasonable, common sense, practical changes, then to me that tells you a lot about the franchisor, and I always say, since I do this on both sides, I've created these documents numerous times and also represent franchisees. I think of myself as very reasonable in the kind of changes that I request. And so when the attorney on the other side, said we're not making any changes, I always, tell my client, well, what do you think about that, right? I mean, this is the person you're about to get into business with for the next 10 years.
And
And yeah,
there's a really good point in that what I'll tell my clients is that when you first start looking at franchises, there tends to be this by the candidate, they tend to have kind of an arm's length view of the franchisor, like they're going to try to sell me something. And they may or may not. A good one is more interested in if you're going to be a good match, but nonetheless, there's that kind of skepticism. But as you go through this process and you're thinking about getting it in a relationship with this franchise, in other words, becoming a franchisee, there needs to be some trust that starts becoming developed. If you can't start finding that you can trust this franchisor that you're going to be working with for 10 years, then you probably not a good decision to make that or consummate that agreement, because if you can't trust them up front, what's going to happen later?
yeah, I completely agree.
So, okay. I have one other question not related to this. Then I see that I get questions out about a lot often is on the entity structure. In other words, if I'm going to go into business, can I do this as a sole proprietorship? Can I do this as a partnership, or should I do it as a corporation? And if a corporation, what kind should I do? Should I do an S or an LLC? What are your thoughts on that, Josh?
Yeah, so there's two considerations when you're thinking about the business structure. The one is limiting your liability, and the second is the tax aspects. So obviously for the tax aspects, you need to get a good CPA, good accountant who can advise you on that. And on the liability aspects, you need to ask, the lawyer. But I can tell you that in most instances, not all, but in most instances, I'm dealing with setting up LLCs or limited liability companies because they're the most flexible, and you're setting that up to be the entity that the franchisee buys the franchise with. You never want to buy a franchise personally. You want to do it through a company so that you can shield yourself a little bit personally. Now, granted, you might have to sign and will likely have to sign a guarantee, but at least you're going to shield yourself with various aspects with a limited liability company. Now, oftentimes with a limited liability company, from a tax perspective, you can still register yourself as an S corp for tax purposes, which will assist in helping you eliminate the self-employment tax, depending on the amount of revenue that you bring in, which can be a savings of 15%. So that's one of the reasons you need to really make sure you've got an accountant who's looked at that. Sometimes, accountants will recommend that you just set up an S corp. I like to do it the other way because, again, there's more requirements with S corps and there's less requirements with LLCs, and because you can sort of take advantage of both through an LLC, I usually recommend doing that. But it certainly, depends on the particular situation.
Okay. Hey, Josh, we do have a couple questions here.
Sure.
One is they're interested to know why item 19 is reported at the discretion of the franchisor. Only about 30% actually show a financial performance representation. Why doesn't the FTC require franchisors to include this as part of the FDD requirement on item 19 as opposed to discretionary?
Uh,
Any
you
thoughts on
know,
that?
yeah, my thought is because it hasn't been lobbied for hard enough. I mean,
Okay.
I think the people, I mean, I think that, to me, like I said, I'm a big fan of financial
Yeah.
representations. I also think they don't report it because I think sometimes it can be a little bit of a trick bag because of the requirements
Yeah.
that you have to do. So they don't want to force it on people. And I think at the end of the day, they figure there's going to be an economic component to that that's going to drive that as well. Because if you don't have one and you get a bunch of franchisees that aren't going to buy into your system because you don't have one, well, then my guess is you're going to start putting one in.
Yeah. Got another question. Let me make a comment here because we're coming up to the end of the hour. If any of you still have comment or questions, you can email myself, Jim at indianabusinessadvisors.com, or you can email Josh. Josh can give his email address again, and we'll get back to you. But we're about at the end. Here's another question. The person's looking at purchasing an existing franchise. Briefly discuss the legal aspects of working with the seller and the franchise in tandem.
Yeah, it's a great question. So when you're buying on a resale, what the franchisor has to approve the ultimate
Mhm.
transaction from the seller. Most often, they're going to require, the franchisor is going to require that you have to sign a brand new franchise agreement. Although I'm working on one currently right now where the franchisor is not requiring that. So the person literally who's buying it is just assuming their
Mhm.
their contract. But what you want to make sure of is that you are comfortable with the franchise, and so you should get the FDD and the franchise agreement fully reviewed. But at the same time, typically when you're going to buy on a resale, you're going to do it through what's called an asset purchase agreement,
Yep.
which is another legal document that the lawyers are going to put together, where you're buying the assets of the franchise but limiting but not taking on the liabilities. The other thing that you want to factor in on a resale that's super important, and that is the lease. If it's obviously a franchise with a physical location component, you're going to have to assume whatever lease they were on. And so often people just ignore that component, and then they get in and they realize they didn't fully understand the components of the lease, or some of the hidden fees or the various components of it. So you definitely want to make sure that you're getting a review of the FDD and the franchise agreement. You're having a really good, solid asset purchase agreement put together that the franchisor is going to have to approve, and that you're having somebody review that lease before you assume it.
Yeah, and in addition to that, in the asset purchase agreement, you'd put a contingency in there that approval by the franchisor, or your approval by the franchisor, would be a condition of the deal going through, as well as acceptable lease term for you as the new leasee. So yeah, those are important aspects.
Yeah, absolutely. Great question, though.
Yeah. Um, I think that's about all we have now. We're just about at the end of the hour. Again, thanks, Josh. I really appreciate it. I think you did a great job. A lot of information here that is important, and there's a lot more that's in here. And fortunately, like I said, like Josh said, it doesn't take 6 months to review this document. He knows how to do it. He's written them, and he knows what he's looking for. And please feel free to email either Josh or me with any additional questions, comments, or thoughts. If we can help you, we'd certainly be glad to do that. And so thanks again, Josh.
Thank you for having me on. Appreciate it.
All right. Thank you. Bye-bye.